Can you all hear me? Welcome, and thank you for staying for the final panel. I think it's a credit to our panelists that you are all here because they're all fantastic, and I'm going to be brief so that we can get to what they have to say. My name is Angela Riley. I am a professor of law here at the law school and the director of the American Indian Studies Center here at UCLA. And I thank you all for being here for this incredible conference and for all the people who've worked so hard to put it together. As we prepare to close the conference with this concluding panel of esteemed guests, I just want to circle back briefly to some of the remarks that were made by our pioneering critical race studies faculty, Professors Kimberly Crenshaw, Laura Gomez, Jerry Kong, and Jerry Lopez, who opened our conference last night by reflecting on their experiences and intersections, personally and professionally, with the work of the late Derek Bell. Through all of their statements, noting that Derek Bell galvanized critical race studies by leaving the academy, twice I think was the remark, that he was willing to bear the cost of waging an internal critique of law and lawyers in his defining work, Serving Two Masters, that he had come to adopt a belief in racial realism in the face of evidence that, in his words, black people will never gain full equality in this country, and that he opposed extreme efforts towards achieving racial integration when it came at the cost of the advancement of education for blacks. We see Derek Bell as a scholarly giant and critic, an activist, and a provocateur in the best sense of the word. Indeed, in his groundbreaking 1987 book, And We Are Not Saved, Bell queried, how are we to assess the unstable status of a struggle that all but the most perversely pessimistic predicted would end in triumph many years ago? So in this, our final panel of the day, our speakers are going to take up Bell's provocative query and ponder the future of race, law, and racial justice advocacy. Because you have their full bios in your materials, I'm going to introduce them only briefly so that we can really reserve the bulk of the time for their presentations and for the Q&A that will follow. So allow me to introduce our speakers in the order in which they'll speak. First, it's my pleasure to introduce Asli Bâli, Assistant Professor of Law at UCLA School of Law; Victor Viramontes, National Senior Counsel for the Mexican American Legal Defense and Educational Fund, and Executive Committee member of the Thelton E. Henderson Center for Social Justice; Priscilla Ocen, Associate Professor of Law at Loyola Law School in Los Angeles; and Latonya Slack, Principal and Founder of Slack Global Consulting, Class of '94. Please join me in welcoming them.
So can everyone hear me as well through this? Okay, great. So we were asked to frame our comments in terms of Derek Bell's project and We Are Not Saved, and I was further tasked with the duty of bringing a global perspective into our discussions today around the future of race, law, and racial justice advocacy. And the core idea at the heart of Bell's project and We Are Not Saved is that racial progress is not inevitable. In response to that wise observation, I think that I want to frame my comments today in saying that the future is international, so that to the extent that we are going to move this project forward, it's going to be moved forward on the global stage. And I say this for two reasons. The first is that the United States is a global hegemonic actor, and so it projects abroad its own racial conceptions, racial structures, racial institutions, and projects. And I'm very interested in my own work in the ways in which this is true, especially in the context of the war on terror. But it's true and iterated everywhere, and I'll focus my comments largely in another arena, in the human rights arena, for our purposes today. The second reason why the future is international is that the most interesting work in racial justice advocacy today happens outside of the United States, and I will turn to that in the second part of my brief remarks. So Bell quotes Charles Lawrence in the introduction of the book to say, racism in America is much more complex than either the conscious conspiracy of a power elite or the simple delusion of a few ignorant bigots. It is a part of our common historical experience and therefore a part of our culture. It arises from the assumptions we have learned to make about the world, ourselves and others, as well as from the patterns of our fundamental social activities. When one thinks about the outsized influence that the United States has at the international level as a hegemonic superpower, you can only imagine what it means when racism in America is part of our fundamental culture how our projections of our power abroad propagate that very culture to other shores. So to the extent that our culture is suffused with race and racism, it is projected onto a very large screen when America acts internationally. I'm going to give one example that I think is really fundamental in the area of international human rights about how this operates in moving the American racial and racist project outside of our shores, and then return to think about what lessons may exist in this example for the possibilities for racial justice advocacy outside of the United States. And this example is around the Durban World Conference Against Racism. So the United Nations system organized a series of conferences on different important topics throughout the 1990s, the last of which was a conference that was to review where we are internationally in meeting the objectives and principles set forth in the Convention on the Elimination of All Forms of Racial Discrimination, which was an early human rights treaty that came out of the post-colonial context and basically created an international human rights framework and mandate to end racism. So the Durban Conference, held in Durban, South Africa, was the last of these major thematic conferences, and it was to take place in September 2001 as the World Conference Against Racism. There was almost immediately controversy over the way in which this conference had been framed. This was because two of the agenda items in the declaration that was proposed in advance of the conference and in the program of action that the delegates hoped to build out from, so a program of action of what the next decade would look like for racial justice advocacy, involved two items that the United States directly objected to. The first was the idea of compensation in one form or another, including the possibility of reparations for slavery internationally. So this was a completely unacceptable item from the perspective of the United States. And the second was a criticism of the ongoing actions of the Israeli government, which were deemed by much of the global South to be an ongoing project of incomplete decolonization. So they understood the Palestine question as continuous with colonial struggles that themselves had inspired the creation of the Convention on the Elimination of All Forms of Racial Discrimination, and they wanted to make it an agenda item. Eventually, the United States, under, at this time, the Bush administration, of course, in 2001, together with Israel, withdrew from the conference extremely publicly. And the conference went from being a conference about racial justice advocacy at the international arena to a story about U.S. foreign policy, a story about the United States conception of the international system, a story about the role of Zionism as a doctrine from the American perspective and from the Israeli perspective. The final declaration and program of action that was produced by the conference, these were the two countries in the world that boycotted this conference, was the subject of fierce debates, even in the absence of these delegations. And in the end, the text that the United States objected to was not included in the final declaration. But this didn't in any way change the legacy of the event. The event was understood internationally to have been a failure in the West, in the global North, because of the U.S. boycott, because of the inability to keep the most influential player at the table at the conference. In the meantime, a non-governmental organization, or NGO forum, met in parallel to the official conference with the official governmental delegations, and they did address Israeli actions, not as part of the official United Nations conference, and indeed they were criticized by the then High Commissioner for Human Rights, someone that the United States had strongly supported under the Clinton administration, a woman called Mary Robinson, who had been the president of Ireland and was now acting as the UN High Commissioner for Human Rights. She heavily criticized this parallel NGO forum for taking up this controversial issue that had led to the U.S. boycott in the first place, and the NGO forum ultimately adopted a statement quite mild, not involving the framing that had been most objected to, but nonetheless critical of Israeli actions. And that led to a set of further knock-on effects. First of all, the UN High Commissioner lost the support of the United States. She was denounced roundly. Tom Lantos and others blamed her directly for the, quote, failure of the conference. Secondly, the U.S. withdrew from all of the human rights activities at the United Nations, stopped participating, wouldn't be seated at the UN Human Rights Council, and so forth. And thirdly, it created a climate through the international system of silencing of NGOs around critical issues, because the NGO forum, which is the only place ultimately where any mention, critical mention of the subjects of slavery reparations or the actions of the Israeli government were ever raised, was deemed to be the problem. That was where the mistake had been made, and so global civil society needed to be brought to heel, needed to abandon these critical and controversial topics in order to bring the United States back on board. In any event, the September 11th attacks occurred 3 days after the conference ended and totally eclipsed any of the programmatic commitments that were made anywhere, ultimately radically altered international relations and relations between states going forward from that moment in 2011. But before that happened, you had American participants who had gone to the NGO Forum, including notably Manning Marable, from the late Manning Marable from Columbia University, who were attempting to resuscitate, who were attempting to connect local American projects, local American struggles around racial justice advocacy, and this also, of course, goes for Kimberly Crenshaw here at UCLA, with this international project, notwithstanding the ways in which official U.S. actions had undermined and indeed condemned the outcomes of the conference. And what Manning Marable pointed out was that the objectives of the conference were to increase coordination in human rights activities and to strengthen networks amongst those combating racism, and that whatever actions governments may or may not take was not the crux of the issue. The crux of the issue was building global solidarity around civil society movements. And so there was an American vision present still, albeit outside of the official delegations at the NGO Forum that had been so widely condemned, of what racial justice advocacy might still promise at the international level. The conference at Durban then was followed by a number of review conferences thereafter, like all of the other substantive conferences, whether they were on population, human rights broadly, women's rights, and so forth. They had review conferences that went on, and Durban had the same exact process that the UN undertook. The Durban Review Conference took place in Geneva in 2009, and the U.S. continued to undermine international efforts to build an anti-racism framework, this time under the Obama administration. So the U.S. not only boycotted the event, but built a coalition to boycott, which included Australia, Canada, Germany, Israel, Italy, the Netherlands, New Zealand, Poland, the United States, ultimately the Czech Republic, and of the European Union countries that sent delegations, they were extraordinarily low-level delegations that were there largely to criticize the framing and efforts of the conference for overly focusing on racism in the West rather than looking at the forms of discrimination present in the developing world. So to the extent that there was a Western or global North presence after the U.S. boycott, it was there to take to task the global South for their internal forms of racism rather than to allow a focus on the kinds of things that were going on and producing, for example, riots in the French suburbs. France was there present, chiding African countries about racism in Africa. The third of the Durban conferences took place in New York in 2011 and had the same wide boycott, this time also adding France and the UK, which went from the position of critics with low-level delegations within the conferences to just boycotting altogether. And the U.S. basically offered international legitimacy to the countries of the West and the global North in their decision to boycott any international gathering addressing racial justice. So this is the first, and this is the critical example that I will come back to at the very end of my remarks, of the ways in which the future is international and that the United States projects its racial or racist projects following the ways in which Derek Bell framed it abroad. There's a second prong that takes up a lot of my own scholarly work, which has to do with the connection to the war on terror and domestic race practices that feed into the way we project our power abroad, literally in the form of our military power. So all I will say on this is that you can trace a direct line from domestic detention practices here in the United States to the kinds of detention practices we've engaged in overseas, extraterritorially, connected to the prosecution of the war on terror and also the wars in Iraq and Afghanistan, that are directly connected to the racialization of Muslim identity in the United States and the turning of that identity into a category of racialized international threat. So I'm just going to give one example to flesh out what I mean in this context. The Office of the Inspector General at the Department of Justice issued a series of reports in 2005 about the conditions under which immigrants that had been detained in the immediate aftermath of the September 11th attacks were treated. And among the things that were detailed in that OIG report, and I'm sorry, I should have said in 2003, in the OIG report included practices involving sexual humiliation, involving invasive body cavity searches. These are for people in civil immigration detention who are being held on some technicality related to their immigration, but because after September 11th, there was a directive through then Attorney General Ashcroft's office that anybody who was from one of 25 countries that were predominantly Muslim plus North Korea was of special interest. And so if there could be any immigration basis to detain them, they would be held under a special FBI hold and only released after the FBI had cleared them on matters not related to their immigration detention. In any case, so there was a widespread detention practice domestically. Sexual humiliation and the use of dogs in particular were detailed in all of the detention facilities in the New York, New Jersey area where these detainees were held. And of course, it was only a year later, in 2004, that the revelations of what was going on at Abu Ghraib and later the ways in which coercive detention practices had migrated from Guantanamo to Abu Ghraib revealed the use of the exact same techniques. And in both cases, they were grounded in an understanding of what Muslims most fear, which is being sexualized or being involved in sexually humiliating circumstances as a result of the alleged influence of the religion and religious identity on their specific vulnerabilities, and fear of dogs. Both of these were just straightforward deployments of racialized conception of identity into detention practices, but because they were projected abroad, they've ended up having a durable influence, not just in the sense that they've influenced the public in a variety of ways, and we've organized in various ways, or have attempted to, within the United States to bring an end to these practices, but they actually have served an exemplary function elsewhere, for Russia, for China, for other countries that have what they deem to be restive Muslim minorities. There is an evolving global practice, if you want, of how do you manage Muslim dissent? How do you manage Muslim populations that are unruly? And that global practice, the toolkit that's been generated, is another example of our projection of a particular kind of power internationally, and our characterization of dissent in a racialized fashion that generates identity as threat domestically in the United States for Muslims, and then projects that same project abroad, creating a new kind of characterization and, if you want, criminalization of transnational Muslim communities generally. The last of the American projects that I want to mention being projected abroad, and I'm just going to say this in the most sort of caricaturish and brief way, but is the project of Manifest Destiny, which is one that very much animates our own founding and the way that the United States has long thought about its project as a city on the hill in the world. But what it has meant, what it translates into, is that we are somehow projecting military force not in an aggressive and imperial fashion, even when we do it to establish military bases in 120 plus countries across the world, but rather as saviors. We're going to save people and enhance their human rights, and so we attack and overthrow a regime, let's say in Iraq, and we do this because that regime had generated tremendous suffering at home. The people of Iraq are passive victims. They're merely human, and what they can hope for is to be saved by an external savior. And this is very much continuous with our own domestic political culture, and one that is, again, a deeply racialized conception of what we can do, and one that's continuous with colonial projects more generally. Okay, so having said a great deal about what the United States may do as a global hegemon and projecting internationally its own racialized projects, then the second reason I said that the future is international is because I think the most interesting forms of racial justice advocacy in response to this internationalized phenomenon are taking place outside of the United States. And so this brings me back to my Durban example. Who is still involved with and leading the Durban process? Who are the countries that are the committee and the board that drives forward the idea that there is a reason to review these practices, that programmatic action matters? Those countries are Cameroon, South Africa, Senegal, India, Indonesia, Pakistan, Argentina, Brazil, Chile, Armenia, Croatia, Belgium, Greece, Norway, Turkey, and Cuba. And of these, most importantly, Brazil, South Africa, and India are notable for not only crafting international coalitions around matters of race, but for actually internalizing in their own domestic legal systems and constitutional orders the requirements of the International Covenant on the Elimination of Racial Discrimination as direct sources for individual rights and for standing before their courts to challenge the practices of the state. In other words, they take this international framework that has been so disparaged by the U.S. and internalize it in their own constitutional orders as a source of norms for social justice and for racial justice advocacy. So Derek Bell named his project for Jeremiah's lament that we are not saved, and that continues in my mind to echo across the globe. And yet to the extent that anti-racism, anti-xenophobia advocacy programs are being framed and articulated, we may still have some hope of pushing this project forward, but what's important to understand is that that hope lies as much in emancipation from American influence as it does in America's own projects here domestically that we've been discussing in the context of racial justice advocacy for the United States.
Thank you for joining me. I'm MALDEF's National Senior Counsel, and I'm in a role where I'm in an organization that is explicitly about race, designed specifically to defend a specific racial group. And as you'll see during my presentation, I've spent much of my last 3 years not talking about race. This is a strategy that civil rights advocates have done from time immemorial. But now, today more than ever, I think it is becoming an increasingly larger piece of the pie for our dockets. And that, I think, comes with some destructive consequences that we can explore perhaps in the question and answer. But first, let me start out with my first slide. And this is kind of what I thought when I went to law school. That the defendant would say, you know, this decision has nothing to do with race. I fired that guy because he's terrible. I promoted this guy because he's much better than the Latino guy. And as a plaintiff, it'd be your job to drag race into the equation and convince the jury that really this is all about race, that they ran out this guy because they don't like Latinos, because they didn't like him and they violated their own practices, they threw out their own policies, and they basically stacked the deck against people of color. And as a corollary to that, when you go to law school, you learn that there's a disparate impact theory that's also available in employment law, and that's a close cousin to this one. It basically, an employer says, you know, I put a 6-foot height requirement just because I thought you needed to be 6 foot to be the job, to do the job. And if you can show that that has no relation to the job, and you can show that that's having a discriminatory effect on a protected group, the court's going to strike that, right? So again, you're bringing race into the equation when the defendant claims it's not about race. But now I'm going to tell you what I've actually been doing. I've been MALDEF's lead litigator on SB 1070 for about 3 years now, and this is a law that everyone agrees, well, everyone in this room would agree, it's an anti-Latino law. And when we're at the dinner table, you know, any kind of social group, everybody's telling me this is a racist law, you know, take it down, take it apart. This law is racist, when the media talks about it. The debate is this a racially profiling law or isn't it, right? I mean, that's the debate we're having. But when we walk into court, none of that is there. What you will hear us say is that we need a uniform immigration system, and the Arizona state-specific system undermines our federal immigration system. So you have MALDEF attorneys standing up and defending the federal immigration system that in most contexts we would say is god-awful, right? And this is what we do. And another couple things I have up on the slide is that everyone agrees that the burden of SB 1070 is borne almost exclusively by Latinos, if not overwhelmingly by Latinos. And one of the reasons it passed is because it effectively burdens Latinos. And even that being the case, we're still not talking about race. And if you read the Supreme Court decision and you listen to the oral argument, race is just not discussed. There was one question that came up in oral argument about why there's no race claim. But the justices know why there's no race claim, because you can't bring a race claim in a facial challenge against this kind of statute. That's how the law is designed. That's basically the way SB 1070 was litigated and up to the Supreme Court with no race at all. And next, I wanted to talk about another piece of SB 1070 that comes a lot closer to talking about race, but still doesn't. For procedural reasons, the day labor piece of SB 1070 got cut off from the preemption piece. And the day labor piece was litigated under, or is being litigated under First Amendment theory. And just last week, the Ninth Circuit held that it should continue to be enjoined. And here, the Ninth Circuit said, well, they're targeting day laborers. They're targeting day laborers because of their relation to undocumented immigrants. And they came very, very close to touching upon race, but they didn't actually do it. And in the oral argument and in the briefing, there was zero discussion about race. The heart of this argument was about the tailoring of the statute, that you were burdening speech when you didn't have to. So you have this speech-based argument when really the elephant in the room is all about race. And I think part of the reason that's happening, and if you talk to practitioners, race claims are getting harder to bring. The inexorable zero case, that means that you've hired no Latinos, you've hired no women, you've hired no blacks, right? Those are the easiest cases. Those don't exist anymore. At California, we've reached the tipping point of diversity where even a racist organization has a couple, right? And that's just how it is. And in every single case, you'll hear that defense. Well, we have one sergeant, we have this one manager, or we wouldn't have promoted him if we were racist, right? And it's a defense with some traction to juries and judges. So we're tasked with making more complex arguments, right? The headwind argument. It's harder for Latinos to get ahead. It's harder for women to get ahead. And that is a more technical, more complex argument that is harder to get juries and judges to buy, right? It's 0.1% more difficult. There's 2 standard deviations between the promotion rates of Latinos and those of whites. Doesn't have the same kind of ring, doesn't have the same kind of force. No less illegal, no less actionable, but harder to sell to judges and juries. And now many of these cases are going to be litigated in front of arbitrators who are bought and paid, not bought, but paid for by the employer, even going to get harder. Oh yeah, and the other one is everyone's married to a Latino somewhere, right? I've seen this defense now 5 or 6 times. Last thing is that pattern and practice has also been severely gutted. So one of the ways you get out from under these challenges to prove that this particular individual was discriminated against is you show this broader pattern. But after Walmart, that's also become harder because now they've linked that you've got to have direct discriminatory evidence from high up in order to bring in the pattern of practice. So they basically gutted the pattern of practice because now, standing on its own, the indisputable evidence of differential promotion rates or differential hiring rates doesn't get you anywhere. But now to my next point. We actually have a race claim in SB 1070. And you are going to see it because that last piece of SB 1070 that allows you to look at someone's immigration status if you believe you have a reasonable suspicion to suspect that they are undocumented, is still there. So what you have here is a quote from the primary proponent of SB 1070, and this is from a piece of our brief where we asked for a preliminary injunction based on equal protection, and the judge didn't really rule on it, so it's still sitting there. And you can see what he said. Welcome to the United States of Mexico. You can see the other one too, equally awful. The next one, accusing the Mexicans of having this cross-cultural conspiracy with Antonio Villaraigosa and Fox to shove in a bunch of Mexican people into the United States. And this is from an elected Arizona legislator. The last one's from the governor. She doesn't want the horrible ills south of the border to be creeping northward. So even this stuff is barely coded. Barely coded. I mean, this is pretty blatant. I mean, the other thing I wanted to express is just how god-awful this law is, and how anti-humanitarian and how mean-spirited it is. And I don't think this has quite gotten enough play. In the First Amendment theory, they basically criminalized soliciting work and trying to feed your family. And they try to throw you in jail for basically trying to work. I don't know any other way to read that. It's just really awful anti-humanitarian policy. The transporting and harboring provision, taking your grandmother to the hospital, taking your child to school, criminalized if that person's undocumented. And then, of course, figuring out who's undocumented based on how you look is now the law in Arizona. And if you're Latino, you better carry your papers because they could ask for it, although that's now been enjoined. And thankfully, everything on this page has been enjoined except for that one piece about questioning you and asking for your papers. And so, as I said, we're getting to the point now where we're having racial discussions, the most important racial discussions in the courtroom, and not discussing race. And what effect does that have on juries? What effect does that have on judges? What effect does that have on the judicial system as a whole? That we're basically not wrestling with the real issue at play. And I neglected to throw out this other example. It's another one I wanted just to show you how upside down and turned around the world is. Right now in the Ninth Circuit, MALDEF is currently making an argument that the federal immigration system regarding harboring and transporting undocumented immigrants should be protected against conflict from Arizona statute. So MALDEF is actually in federal court protecting an anti-harboring, anti-transporting provision. But that's what we have to do these days to get the results. I don't apologize for that. I don't think there's any other way to do this, but that's what's happening. The last thing I wanted to show you, we talked about some of this stuff being barely even covert. I wanted to present to you a training for Arizona law enforcement with regard to how to identify if someone is undocumented without using race. And I don't think there's anything more damning than their own training on this, and so I just wanted to close with this video. There you go.
The person doesn't provide you with that identification. If they say they don't have any identification. If you have some reason to believe, in the absence of that identification, talk about the kinds of things that might alert you to the question of whether or not the person is unlawfully present.
In vehicle registration, counter surveillance or lookout activity in company of other unlawfully present aliens. Location, including, for example, a place where unlawfully present aliens are known to congregate looking for work. A location known for human smuggling or known smuggling routes. Traveling in tandem. Vehicle is overcrowded or rides heavily. Passengers in vehicle attempt to hide or avoid detection. Prior information about the person. Inability to provide his or her residential address. Claim of not knowing others in same vehicle or at same location. Providing inconsistent or illogical information.
This one's my favorite.
Demeanor, for example, unusual or unexplained nervousness, erratic behavior, refusal to make eye contact.
If the person has real difficulty communicating with you in English.
Thank you.
Thank you so much. It's hard to follow such wonderful presentations, but I'm going to try. But before I get started, and because I have the floor, I do want to say a few words to all of you. First, I want to thank the organizers, the students, the alumni planning committee. Words can't adequately express how deeply honored I feel to be included as a panelist on this closing panel, how blessed I am to have benefited from the intellectual strength of the founders of this program and this project. Like so many here in this room, I have and continue to call UCLA Critical Race Studies my home, although Loyola is becoming a close second. This is a place where I've been encouraged, challenged, critiqued, prodded, and some of these things are all happening at once. But like family, it was in the service of pushing me and others to become our best selves. To become foot soldiers in the broader movement for social justice. This is a place that adopts an ethos of family, an ethos of because I am because you are. We don't get to say this enough, and now I say we, I'm speaking on behalf of the graduates of the program, folks who have passed through these halls and have benefited from your wisdom. We don't get to say this enough to those of you who keep this movement moving, who inspire us to strive confidently and with purpose into this space. Even though we often want to walk in the other direction, out the door, through the exits, to the 405, and to keep it pushing. And quite frankly, you all have kept us sane with the knowledge that we inherit a rich and liberatory legacy of speaking truth to power in an institution that would like nothing more than to condition our admission on our silence. So, very clearly, I want to say on behalf of myself and probably everybody in this room, to the faculty and staff and the students who keep this program moving and have organized this conference and are celebrating this 10-year anniversary and continue to keep this place we call home. Thank you. So, what I actually was asked to talk about. This panel has a task that is at once challenging and intriguing, considering the future of race and racial justice advocacy, particularly in light of the prescient observation of Derek Bell regarding the permanence of racism. So perhaps the question ought not to be the future of race, but the future of racism and how it will persist and persevere, notwithstanding our best efforts to bring about its demise. I consider this question in the context of mass incarceration, a burgeoning system that both panelists that have preceded me have talked about, one that regulates and captures the bodies of black and brown men and women at rates unprecedented in the history of the world. In particular, during my time, I want to flag an emergent trend as the arguments of anti-prison activists have been gaining traction in a time of austerity, causing a reduction in the prison population for the first time in decades, particularly among African American women, and how at the same time we are seeing the expanded use of state surveillance and regulation through the criminal justice system. In other words, I want to ponder a probable future of racism and racial control in which we will experience both declining incarceration rates of men and women of color and a corresponding expansion of the criminal justice system. In flagging this trend, I want to call on the work of Professor Crenshaw to sketch out the ways in which the system is engaging in retrenchment through reformation. How so? Well, it engages in this retrenchment through the reformation by making a move that we have seen so many times before, a greatest hits, if you will, by co-opting the liberatory rhetoric of anti-incarceration movements, such as calls for restorative justice, as a means for justifying the expanding scope of the criminal justice system. I'll discuss 3 points on the future of race and incarceration and then close. First, I want to talk about interest convergence in the era of mass incarceration. Second, I'll discuss the shift from mass incarceration to mass surveillance and regulation. And third, I want to talk about the implications of this interest convergence and these shifts within the criminal justice system. So first, interest convergence in the era of mass incarceration. This is a paper I wish I could read that Derek Bell would author today, and I'm so sad that he's not here today to do it, but we are here to carry on, and so I will talk about interest convergence in the era of mass incarceration. So over the past 30 years, civil rights and anti-prison activists have called for a reduced reliance on incarceration and for institutional rather than individual responses to social problems such as poverty, homelessness, drug addiction, maldistribution of educational resources, health care, mental health, and the like. There have been emergent critiques of the criminal justice systems as a system of racial control constituting the new Jim Crow. And these critiques have been gaining traction in popular discourse. At the same time that these critiques, that these advocates, that these movements have been gaining traction, liberals and conservatives alike are attempting to cut costs at the state and local level in the face of rising unemployment and falling revenues. So here is where I'm describing this interest convergence. As we see these emerging critiques, as we see these emerging racial disparities, at the same time states are attempting to cut costs, local governments and states, so I'm giving a nod to the previous panel, I'm paying attention here to localities, began to adopt smart on crime approaches that diverted individuals away from incarceration and into supervised behavior modification programs that have come to be seen as more efficient at reducing recidivism and efficient at reducing costs to the states. And they've done so under the auspices of restorative or community justice programs, utilizing, again, the same language as anti-prison activists, civil rights, and anti-racist organizations. So what's the result of this alignment or interest convergence? So over the last 3 years, for the first time in almost 3 decades or more, we've seen a decline in incarceration rates. According to a recently released report by the Sentencing Project, since 2008, again, the year that we began to experience the impact of the Great Recession, we have seen declines in the overall number of people in state prisons. Remarkably, we've also seen some declines in the number of black men and women incarcerated and a reduction in the overall disparity between whites and blacks, although the overall rates and the overall disparities remain significant. So for example, again, according to the Sentencing Project, from 2000 to 2009, the rate of incarceration in state and federal prisons for black men fell by almost 10%. And for black women, who previous to this decline had constituted the fastest growing prison population in the country, declined by almost 30%. In 2000, black women were incarcerated at 6 times the rate of white women. In 2006, that disparity was cut in half, such that black women were incarcerated at roughly 3 times the rate of white women. The explanations in the reduction in these sorts of disparities and the decline in imprisonment rates has been attributed to changes in policies with regard to the war on drugs, for example, and changes in terms of the ratios between punishment for crack cocaine and powder cocaine. So this is great news, right? A successful moment of interest convergence, and yet we are not saved. We see significant increases in the rate of incarceration for Latinas, which has increased by roughly 23% between 2000 and 2009, perhaps not insignificant because of the increase in surveillance of Latina bodies as a result of the immigration discourse. Moreover, we're seeing the simultaneous expansion of the criminal justice system in other areas. Consequently, these declining incarceration rates may also signal the emergence of a new, yet less troubling expression of racial subordination through the criminal justice system. And here I want to talk about how this is occurring. And here I want to mark this moment of the transition from mass incarceration to mass surveillance and regulation, or maybe I should say massive surveillance and regulation. So Bell often used speculative fiction to tell stories about the logics and permanence of racism in the United States. So since it's the end of the day, almost, let me kind of tell a story, right? Maybe I'll do that. So imagine that the year is 2024. We're in a crowded courtroom in Los Angeles County. It's filled with poor people of color being adjudicated through the criminal justice system. So now at this point, you might be asking yourself, why go to the future? We can see all of this today. Leave the speculative fiction to Bell or Octavia Butler or someone else. But what are they there for? They're there for being homeless, for mental health treatment, for drug addiction, for domestic violence, for driving while intoxicated, because they're troubled veterans, because they're people accused of prostitution offenses, for truancy, for child support, for gambling, for family treatment, for reentry services, for people reentering their communities with histories of substance abuse. There are gun courts, and then there are all kinds of other community-based, problem-solving, restorative justice courts that are too numerous to mention. And today we have thousands of these courts, and they're only proliferating. So by the year 2024, we'll have thousands more. These courts often divert offenders away from incarceration. Here, I want to mark the relationship between the decline in drug offenders in state and federal prisons and the activities of these courts, diverting offenders away from incarceration. In exchange for agreement to participate in court-mandated treatment programs, which provide services under the auspices of the criminal courts rather than social services agencies. This requires often weekly appearances and drug tests. The failure to comply with results in possible incarceration. It requires the waiver of traditional constitutional rights that apply, at least as a formal matter, such as the right to trial, the right to counsel, the right to confront witnesses, different rules of evidence, as Eric Miller and others have noted. It extends the court supervision into the most intimate aspects of people's lives with an eye toward reforming problematic behaviors of the individuals rather than challenging the institutional settings which produce social problems. In some cases, and in many cases, court supervision can extend beyond the time frame that would have been permitted under formal sentencing rules, again, because it requires a waiver of defendants' rights. So again, we see this intrusion of the criminal justice system into a variety of different spaces under this auspices of reform. Note that none of these courts, however, are directed at reforming inequality in schools or universities, in housing or employment markets, or other institutional factors that lead to the social harms that produce people to populate these courts in the first place. So what are the implications of this dystopian future with a criminal justice system that seems to have no bounds? So let me talk about 5 and then I'll close because I see I'm running out of time. So one is that we see the expanded scope of surveillance in the criminal justice system, again, into the intimate lives of poor people for longer periods of time. These courts are often engaged in attempting to regulate behaviors, to correct people, not these institutional settings or problems that produce the social harms that people are experiencing. So it can intrude into their family lives, it can intrude into their employment lives, into their homes, it produces constant contact with parole officers and other agents of the state, with judges, with courts, and all under the threat of incarceration. It reinforces the neoliberal project of directing funds away from vital social services and other institutional interventions in favor of individual behavior modification through courts and the criminal justice system, and critically, further starving the welfare, the social welfare state of vital funds. It ratifies the notion that inequality is a result of bad decisions and bad people rather than institutional racism. The language that it uses, the language of reform, legitimizes the criminal justice system as a fundamentally fair institution, and it solidifies its role in managing racially marginal populations rather than disrupting it. And again, there's no disruption of the racial logics that animate the overall system of crime and punishment. This is all very depressing. But as I was thinking about this, I was going to stop there. But as I was ending there and thinking about how deeply depressed I was by all of this, I thought about a line that just popped into my head of a County Cullen poem called "And Yet I Do Marvel." He says at the end of his poem, after engaging in a long sort of conversation about the woes that he is confronted with, and he says at the end that, "Yet I do marvel at a curious thing, to make a poet black and bid him to sing." I think that this calls forth the notion of redemptive suffering, or what Dr. King called the power to transform suffering into a creative force. Anti-racism, anti-incarceration, and more significantly, the language that these movements use in the context of prison abolition, for example, it shows us that these movements are gaining traction, that the language that they use in defining who we are as a community, beyond the simplistic language of retributivist punishment that aligns so much with this neoliberal project, that the power of our language can align, our creative force can align with radical transformation of society. It gives us a space to think and to struggle. It also tells me that this struggle, while not resulting in the total collapse of the prison or mass state regulation and surveillance, forced a change in our thinking about the possibilities and about the ability of suffering to produce new ideas about how the world should be organized, even if the end is not fully realized. This suffering, this mobilizing of so many, it tells me, may have been incomplete, but it was not ineffective. It gives us some validation that our language, our ideas of a new world are powerful, that they can and will produce something new, and it tells us that we must protect the meaning and deployment of that language and protect our vision with all that we have against the forces of retrenchment. And for all that, and because of all of that, despite this deep disappointment, and yet I do marvel. Thank you.
Thank you for inviting me. It's good to be back. If you were here last night, you probably heard the question that was asked of the panelists at the end, asking them to recount some of their most positive moments here at UCLA and some of their proud moments in creating the Critical Race Studies program. And it reminded me of a proud moment from my time at UCLA. So a little context for you. I graduated in 1994, which meant that my class was just about to complete our first year when the 1992 uprising occurred. That seminal event affected us all in so many ways, but especially those of us who were taking the civil rights classes. We didn't have the seminar, the program that you all have now, and in the public interest program. And being here in LA that summer and in the fall and the following year when so much was at stake and opportunity seemed to be ripe, it was really a pivotal moment. We were anxious to make a difference. We interned at civil rights law firms, we worked for public interest law firms, and volunteered with the newly formed community organizations that were looking to make sense from and meaning from the violence. As students, we bonded in a way that probably would not have happened otherwise. That closeness also led us to believe that we could change the world, but especially we wanted to change UCLA law. So we were actively involved in admissions and faculty recruitment, giving the administration hives on a regular basis, I'm sure. So when it came time for commencement 2 years later, we decided we wanted to change that as well. A few of us hatched a plan and organized among BALSA, MBLJ, La Raza, APALSA, and others to vote for Kimberly Crenshaw as Professor of the Year and Derek Bell as commencement speaker. We organized the hell out of our classmates, making sure that those folks, you know who they are, the ones who show up to class on an as-needed basis, we made sure that they came to school that day and voted. So it became a mantra, vote. Bell Crenshaw, Crenshaw Bell. And when the votes were tallied, they won. On commencement day, we were so excited, and although I don't remember too much about what Professor Bell actually said, I do remember how I felt, and similar to how many of you probably felt the first time you read his work, validated, justified, and electrified. And in classic form, he confirmed what we already knew to be true. That day I remember how collectively we were so proud on stage, listening to both professors in between whatever was the 1994 equivalent of fist bumping. I remember, supportive nods and knowing smiles among my classmates. But I also remember looking out into the audience and seeing various states of shock and horror on the faces of the administration. Some of the attendants, perhaps they were parents of white students, maybe not, had looks on their faces that plainly said, "How in the world did this happen?" They were horrified, but we were not deterred. However, afterwards, I experienced my first of many lessons about organizing and advocacy, including how success can lead to unintended consequences. As I learned that after we graduated, tradition was altered, and the graduating class was no longer allowed to vote for a commencement speaker. Rules changed, racism mutated, lesson learned, but the struggle continues. So enough about the past. We're here to talk about the future of race relations and race-based advocacy in the U.S. I've spent the last 20 years of my career working with nonprofit organizations, unions, and philanthropic organizations, all dedicated to social change in some way. And I would suggest that many of you, if you're not already working with these institutions, will come into contact with these organizations over the lifetime of your career. In the social justice world, it's inevitable. So what's happening in these fields? What are some of the trends that are going to impact how we address race, racism, and racial advocacy in the 21st century? So increasingly, philanthropists and nonprofits are looking to effectiveness, accountability, and innovation. These are hot topics, and there's a lot of pressure from the outside, but I also think there's pressure from the inside, because what we're realizing is that permanent solutions to the problems that we have are elusive. In philanthropy, it's the sort of nervous, anxiety-filled conversations that fills the hallways and boardrooms of many philanthropic institutions. What if it doesn't work? Despite all the money, time, effort, energy we put into this initiative, project, grant, organization, leader, etc. Providing a grant or donating to an organization is the ultimate belief in the possibility of change. And as Jerry King said last night, often despite evidence to the contrary, right? Why is homelessness still a problem? So where's the race in this discussion about effectiveness, accountability, and innovation? So there are a couple of facts to consider. The reality is there are fewer race-based institutions. Multiculturalism is key, but the old strategies are falling apart. You may remember, and it was mentioned in our last panel, that California recently changed the rules so that our statewide redistricting procedures created a Citizens Redistricting Commission that would allow citizens to apply and serve and draw lines for the next 10 years. Communities could provide input into the process, give testimony and data to inform the Commission's redistricting plans. As in years past, a few ethnic-based organizations got together and developed plans to conduct outreach and training to ensure that low-income people and people of color were not excluded from this process. My colleague's organization was one of those organizations. My former employer, the Irvine Foundation, supported this work. However, there was a problem. Because NAACP LDF in Los Angeles had closed its doors a few years prior, there was no one to represent and organize African American voices. So what were we to do? There was no easy answer. We faced the possibility that redistricting and voting rights, areas that African Americans have long fought for, would be without an African American voice in California. When we asked, some organizations could not spend so much time and energy on this issue. Others didn't have the expertise or the knowledge. The days of having one-stop institutions that can address every issue are gone. In the end, a coalition was formed with support from activists and funders that conducted outreach to Black residents. But it was a moment to consider, because the things that had happened in 2000 and in 1990 and 1980 and previous years were not going to happen in the same way again and won't happen in the future. Post-racial rhetoric also infects discussions, and this affects how nonprofits and philanthropic institutions work. Organizations specifically addressing issues of race and racial disparity are no longer the darling, if they ever were, of the mainstream philanthropic world. There's a sense that the old ways are ineffective to address the problems that persist, such as education projections for African Americans and health disparities for most people of color. There's a sense that the needle is moving incrementally too much so for our smartphone-savvy venture capitalists get answers in an instant world. Meanwhile, the country also continues to dance awkwardly, ineffectually, even rudely around questions of race. Recent examples in popular culture, ranging from the tragic to the offensive, including what happens at the Oscars and with the Onion and, Baby Bennett and Chris Dorner, demonstrate how ineffectual we really are at dealing with our differences. A quick read down the comments section of any post, tweet, or article that has anything to do with race shows just how far we are from the ideal. And it's depressing, like my colleague said. And the reluctance to delve into these issues in any meaningful or constructive way is a virus that's also present in our nonprofits and in our philanthropic institutions, despite what you might think. So where does that leave us? We're challenged to answer for ourselves what is effective, what's working, and to prove it with results. Sure, there will always be a need for service delivery models, but increasingly there's a challenge to do more. It's not enough to bring people in, serve them, and then turn them away and say that this is what works. You must use metrics, evaluation, research, and science, such as using randomized experiments to prove that what you're doing works. Right around 1992, LA birthed several community-based organizations, including one that was featured on our last panel, the Los Angeles Alliance for a New Economy, that use grassroots community organizing as a core part of their work together. They organize, they go door to door, they work with communities. The triangle that was presented showed a clearly developed campaign and plan on how to outreach to a community and bring in communications, policy advocacy, and organizing. What's key to this is that the organizations rely on the communities. The ideas are generated from the ground up. Some organizations, like Communities for a Better Environment, for example, work with lawyers to shape policy. But the concern and the pendulum ultimately rests with the community's needs. Organizations measure their effectiveness in these areas by showing, obviously, policy change. A law was changed. But also, how many people were engaged in a particular issue and then take action based on that issue. They take accountability into concern. They do systematic engagement, they work with leaders, and they become interested in seeing social change occur. This is going to be the wave of the future. This is what organizations will need to have in order to say that they're effective. The second issue is accountability. Tools such as organizing and advocacy demonstrate how communities and organizations, rather than dictating what needs to be done, develop a way to hear from and learn from those communities. So they can have connection by connecting to a community around education and other issues. But it's also important for donors and donor activists and others to ask the organizations you support, how effectively are you addressing these issues? How many of you in the room are volunteers with a nonprofit organization? How many of you sit on the boards of a nonprofit organization? Keep your hands up. How many of you donate money, time, services? Almost everybody in the room, right? Have you ever thought about asking those institutions, how effective are you, and how do you know that you're being effective? This is what philanthropy does, what program officers do, but increasingly it's important for organizations to do that work internally, particularly if you're working with an ethnic-based organization that's dealing with race. And I would say, similar to what my colleague just mentioned about not talking about race, that this is an area where nonprofits will be challenged. I'll give you an example. There's an organization called Urban Habitat in the Bay Area, and they have developed a curriculum and training to train people to sit on boards and commissions because they have identified that this is where some real change occurs in California. By sitting on boards and the commissions, you can develop the leadership to work in your behalf and based on shared values and interests. So the program is not just for people of color. It's for people who have identified that they believe in shared values around affordable housing, land use, environmental concerns, and health, and jobs for people of color. And so people get involved in this organization and understand, here's what we're working for, and here's the view that we will have when we get on that commission or get appointed to that board. The final issue to look at is innovation. How are nonprofits, organizations, and philanthropy looking at scholarship and creativity to address issues that they're concerned about? This applies to fundraising and outreach, and given the recent success of the Obama campaign, there's a lot of pressure on nonprofits to replicate that model. It's somewhat unfair because organizations are not looking at time-limited issues. It's easy to focus on election because you have a certain date that's in the future that's coming. But with respect to fundraising, connecting to many donors, working with small donors, working on autonomy, the values-based ideology that the Obama campaign used so well. These are some lessons that nonprofits can take and use and work with. The key is to innovate, to look at local expertise, and to look at different ways of approaching things. One concept that I want to share with you is called design thinking, and there's actually a handout that has a link to an article that shares more about it. And in design thinking, people go into a community not with preconceived notions and ideas, but they rely on the community to know the answer. They get the answers not necessarily by looking at focus groups and asking them, but becoming embedded and looking for inspiration within the communities themselves. They use data collection and observation to find information. When I was at the Irvine Foundation, I worked on a project, California Votes Initiative, where the goal was to find out what motivates low-income and ethnic communities to get to the polls. These are the folks who are not usually targeted by the mainstream campaigns. They're folks who don't have the opportunity to get the numerous phone calls and mailers that maybe we get in the mail. And so in this project, researchers were embedded with the community organizers. They went door to door. They were sitting in on the phone calls. They analyzed the information that was going out. They asked questions like, the organizations would ask questions. Well, should we provide this information, this voter pamphlet, in language? Does it need to be in Korean or other languages? How do we determine, how do we know from the voter polls what's most effective? What message works best if you're a 35-year-old person of color living in Koreatown? So these kinds of questions were the ones that the organizations were able to pose, and then they were able to get answers and results in real time, and to be able to see from election cycle to election cycle what was working. So again, it's an election, so it's a little bit different, but I think organizations really have to think about how they're going to prove and know that they work and that things work. So design thinking is one example. It's not, the answer to everything, but it does involve a lot of considering what is important, considering what comes from the community, and figuring out, using different disciplines, how to solve a problem. There's one of the things that doesn't really work in design thinking is that there's an opportunity to discuss, or an area for opportunity is there's an opportunity to discuss race in design thinking that hasn't come up. What does come up a lot is culture. People talk about culture, and how that impacts whether or not you support or don't support a given institution. And so there's something that we can take from this. We can take design thinking or social innovation with all the limitations that it has, but also adapt it to our purposes. How does this involve your career? Lawyers working with cases, involving the community, individuals working with, supporting, or engaging with nonprofits. You all give your time, money, and your causes, your time and money to causes that you believe in. And as donor activists and advocates, ask how the institutions you are supporting, and that includes philanthropy, how are they effective? How are they accountable? How are they innovating? And are they addressing race and systematic racism in ways that address the problem or cover it up? We may not solve racism in the 21st century, but as Bell states, we must continue the fight with new tactics, strategies, embracing the latest thinking, but also challenging the status quo with our nonprofits, our donations, and our philanthropic institutions. Ensuring effectiveness, accountability, and innovation are part of the discussion can help bring the intent to do good closer to actually doing good. Thank you.
Well, thank you all very much. I just wanted to make a brief comment to sort of tie together a little bit of what we've heard, and then we will do an abbreviated Q&A. Before I turn it back over to our panelists, I'm giving each of them 90 seconds to give a final response to what we've discussed here today. what I really love about this panel is I think that it's really touched on and highlighted a whole variety of things that we can take away from this incredible gathering. Looking at global movements and looking at how America's own racial history and baggage translates not only into our impact on the world, but also in our place in the world in a moral hierarchy. Thinking about shifts in law and policy in the face of massive demographic changes in regards to migration and immigration, something we see in Los Angeles probably more than almost anywhere else in the United States. And then turning domestically and really focusing on impacts at the community level, at the local level, seeing, for example, what I see as a moving groundswell against the mass incarceration of people of color in this country, how that relates to our vision of who we are, how it relates to our place in the world, and of course thinking about activism and philanthropy and the growing opportunities to really effectuate change in so many ways. So I think that even though there were some depressing notes in the presentation, there was also a lot of energy, and I think the impact of our speakers in thinking about the ideas of innovation and really the idea that although racism may indeed mutate, our problem solvers, like our panelists and many other people in the room, are equally or more nimble and able to move and to change and adapt with those changes as they arise. So with that, I want to open the floor to a couple of questions. If someone wants to ask the first one. Yes.
Well, I mean, I think as litigators, you have to take the tools you have, and you come to a place like this because it equips you to take down destructive laws. And if you've got to make a CEQA claim, you make a CEQA claim. If you've got to bring a preemption claim, you bring a preemption claim. There's always going to be a place for race claims, equal protection claims, Title VII claims. But when I first interned at MALDEF, I saw the broad scope of theories they were using, and I was shocked. But now as I do it more, it's the norm. And looking forward, because the courts are increasingly shutting off these race-based claims. And, you know, implicit in the presentation is if we can't strike SB 1070 on an Arlington Heights equal protection challenge, I mean, that doctrine's pretty much, you know, gutted. And so the traditional avenues, they'll shut them down. And then you think of another one. I remember as a young attorney, when the Supreme Court gutted Title VI and said you couldn't bring impact challenges against federal recipients, I was on the floor and I was like, oh, this is the worst thing ever. Civil rights is over. We can't go after colleges anymore. And my supervisor just, you know, got back to work and kept going. And I think that's really our challenge. Just, you know, come back.
Another question? Did you want to respond, please?
To comment on that briefly, I think one of the things that I was attempting to say in my comments, and I think kind of building off of what Victor was saying, is that as advocates, as activists, as folks who consider ourselves part of movements, we also have to be attentive to how our work will be utilized, how it will be deployed, perhaps in the service of the very causes that we're attempting to resist, or the very forces that we're attempting to resist. And so I think, you know, that's one of the things that we have to struggle with, is anticipating the way in which we can provide ammunition to our enemies, essentially. How can we be better at anticipating the potential harms that may flow from our activism and anticipating them and responding to them. So in the context of, you know, litigation that is attempting to contest a racialized system of immigration enforcement in a state, or a racialized system of policing or whatever, that seeds, for example, questions around race. We know that we're doing this deliberately in order to win that particular issue. We do have to think about how that participates and capitulates to a broader notion of colorblindness that is functioning to discipline and silence all of us. So I think we just have to be careful about how we're engaging in advocacy, whether it's related to prison reform, prison abolition, or police reform, or wherever we find ourselves. I think it's a critical concern that we have to be thinking about and remain vigilant about.
Thank you. Another question? Yes.
I guess I just wanted to make the pitch for changing the jurisprudence. I mean, I realize it's a tall order, and I totally understand the need to litigate in ways that will win for our clients and for communities of color and with communities of color. But I guess, there are many people on the panel and in this room, I think, who have ideas about that. So I don't mean to be a Pollyanna about it, but I do think there's a case to be made for us to win and to talk, and to win with race claims. And so obviously litigation is not the only response or the only tool that we have, but if we were talking about that, I would hope that we don't give up the idea that, there's science that can attack the intent doctrine, there's changes in the way that people view everything from gay marriage to what have you. I mean, we can talk about things. I guess I just hope that isn't. Or I'll leave it at that.
Panelists?
Yes, agreed. But I will say, though, I was actually talking to folks yesterday after the conference, and we were actually talking about the litigation around SB 1070 and how we thought that it was actually an effective way in which advocates utilized, although they were making non-race-based arguments, the way in which advocates on the ground and movement activists took the litigation and to mobilize the community more broadly, to utilize the litigation more instrumentally. And I think that that's one way to sort of navigate that terrain that you're talking about, to sort of both expand the conversation about race, racial inequality, while doing some of the arduous work that has to be done to win the particular battle that's in front of us.
I think
go ahead.
some of the retrenchment you're seeing now is a result of a very conservative Supreme Court. Some of that could change. Until it does, we do what we have to do.
Go ahead.
So again, my presentation obviously is international, global, so it's quite far removed from, in some ways, U.S. courts. But it is worth noting one thing. It's true that we have a very conservative Supreme Court, and that's driving some of these doctrinal innovations. But actually, other courts in the international system have been willing to pass judgment on the United States where U.S. courts are not. So as an example, the European Court of Human Rights recently basically imposed heavy penalties on countries that were willing to cooperate with the United States in its rendition program. That's not something you can challenge in U.S. courts. It's been impossible, totally foreclosed by the Supreme Court, but yet in other places people have been able to get victories. And that actually has a kind of impact. I mean, the Supreme Court imagines itself as this kind of global constitutional leader that's invited to conferences around the world in places like South Africa and Brazil to talk about the wonderful sort of race-based justice system that the United States has been able to develop since the 1960s. Well, first of all, there's nothing standard-bearing about that system any longer at all. And if anything, they have to go to places like Brazil and South Africa to be schooled about how backward the U.S. has become in terms of legal protections. And that does have, basically the world is passing judgment on the United States for its complete failure to develop judicial systems that are actually able to actively develop doctrines that address the form of racism today, while the rest of the world has constitutional systems that are attempting to do precisely that. So there are other avenues to shame, essentially, our own system for having, failed its promise.
I apologize for remaining questions. We are at the end, but I did promise my panelists all 1 minute to say final words about whatever they wanted, which I stole from NPR's end of show rant, if you've heard of this. I love it. So you can talk about whatever you want. And so we'll start at the other end and start with Latonya and move this way. Final thoughts.
I just want to leave you with a cautionary story, one that circles around in international philanthropy in particular, about a funder who goes into a foreign country and notices that in this village there's women who are leaving the village and walking for miles to get water from a well that's distant. He asks people, the funder asks people, would you like to have a well that's close by? And they say yes. So the funder goes and spends money and builds a well in the village, thereby eliminating the need for people to walk miles, women to walk miles to get water every day. Goes back to his home country and then finds out that there are reports that there are problems. People aren't using the well that's far away. No one's going there. And worse, that the well that's in the village, it has contamination and there's problems. Goes to investigate, finds out there was no contamination. But the problem was that when you took away the ability of the women to walk from their village to the well that was far away, you took away their time to have social interaction, their time to talk, their time to plan, to organize, to get away from their families. If they were experiencing domestic violence, to not have to be able to work out those issues with their fellow village members. And so it's a cautionary lesson that I think applies to advocacy, working with communities, that it's not enough to just listen, that you need to make sure that you are finding out from the community and listening to the community and getting information in real time about what works and what's effective before you build a well that nobody's going to use. Thank you.
Thank you. Priscilla.
As we were talking, I started to think about the Harlem Shake. Like the new Harlem Shake and the old Harlem Shake. And they are not the same thing. So let's just be clear. And why am I bringing up the Harlem Shake? Because I think it goes to this question of co-optation, right? It speaks to how powerful we are as we use, again, this idea of redemptive suffering, that we have to be protective of our ideas, of our spaces, of our communities, and to anticipate people taking and doing something else with that form because they know it is so powerful. So I guess what I'm saying is we need to be coming with response videos. We need to be thanking Melissa Harris Perry for breaking down the Harlem Shake. We need to be showing folks what it really looks like. And we need to reclaim that language. So sort of taking a page from sort of popular culture at the moment and applying it. It's probably the first time the Harlem Shake has been mentioned at a critical race theory conference. So I'm happy to mention that as a cautionary tale, but also one that I think is inspiring.
Thank you. Victor.
I think I spent a fair amount of time talking about some of the challenges we face in litigation, and that's the traditional avenue by which racial minorities challenge discriminatory practices. But one of the things I wanted to also touch upon is that in California, because of the demographics, there's this new avenue that's available to us, and that's the legislative process. And you've seen things like AB 540, you've seen the California DREAM Act. And so as a lawyer, I'm bred to fight and, litigate and stuff. But that's where you end up if you lose the fight, right? I think increasingly we got to focus on winning the fight legislatively, and not only to prevent these horrible statutes that we're having to fight in court, but to get progressive, positive policies that work to benefit communities of color. And we really have an opportunity to do that now. And my hope is that, especially in California, we can be the sort of the place that shows other people how to do it correctly.
Thank you. Asli.
So I'll end again by noting the point that Manning Marable made. So the United States is certainly not an inspiration around the world based on its carceral system, its criminal justice system, its jurisprudence out of the Supreme Court, and so forth. But it is actually inspiring for other reasons. So, for example, we have an international LLM program here at UCLA that attracts now groups of students from Brazil, from South Africa, and elsewhere who are inspired by the work of Kimberly Crenshaw and come here to pay homage to that work and to learn from her example. And she's not the only one. Actually, the Harlem Shake is a great example. The inspirational side of it is that people identify with Harlem as a place where there were important struggles that were fought and won in their own imagined moment of what those fights look like. And so they appropriate that language in order to fight their own fight, which is, again, against a social justice advocacy fight in places like Egypt and Tunisia, where people see a direct connection. And so what Manning Marable said is, look, it's not about what the U.S. government is doing at this conference. Whatever the international media may say, however it may get framed, it's about global civil society connecting one struggle to another and imagining a movement that can produce change. Now, that change may not be produced first and foremost in the United States. This is why I'm saying the future is international. These battles are being won in other places where they're not stymied by this kind of Supreme Court or this particular kind of judicial discourse, and we can learn from those places too. It's not just that the United States is a city on the hill that gives its shining example to the world. We have a lot that we can learn from looking at these other systems and watching the way in which the inspiration they've taken from historic struggles in this country are now generating victories abroad.
Please join me in thanking our panelists. And now I'll turn it over to the director, Jocelyn Coley, for final words. Do you want me to stay up there?
Sure. So I will keep this brief. I just want to thank again all of our panelists here, all of the panelists from earlier today and yesterday, and all of our moderators. Thank you so much for your time. And I want to thank again all of the alums who have helped us put together this amazing program. And of course to our CRS students who have volunteered their time and energy. I think Teresa Zen and Jennifer Ganata are outside, but they have been our student volunteer coordinators. They have done such an incredible job. They've been at my office till midnight most nights this week. They have been working weekends, and even though they are not here, I think we can still give them a round of applause. And thank you all. I have been so inspired and so moved by the energy and the community I've seen here the last 2 days, and I know all of you have been too. I'm looking forward to continuing these conversations, to continuing the connections we've made at our inaugural alumni celebration and fundraising dinner that will be held at Covell Commons. Before the dinner, we will be having a book reception in honor of Devin Corbato, whose book has just come out. All of you are welcome to come to the book reception, regardless of whether or not you're coming to dinner. We do have shuttles that are waiting outside to start taking you over to Covell. I really recommend that after this you head over to the shuttles. The shuttle will also come back to take more people. For those of you who are staying on to for the dinner, there will be shuttles at the end of the night. For those of you who are just staying for the reception, the shuttles will be heading back here at 7:30, so you can stay just for the reception if you would like. And also, before you leave, I really ask that for those of you who are getting MCLE credit for this, we need your MCLE evaluations, and if you've not done so, you may pick up a flash drive outside. And for the rest of you, we also have evaluations, and I would love for you to spend a couple of minutes of your time filling those out. It's really important for us in order for us to think of ways that we can keep expanding on this dialogue. Do I have a question? Sorry.
I just want to say thank you to everyone. I got to say, I graduated from here more years than I care to say, because it makes me feel old. And I got to say, I really thank you for bringing the practice and the theory together again, for reminding me why I do the work that I do, why I love my friends who do the work that we do, everybody is here. We're really a community, and we love you, and thank you, professors and students. If you're still here, thank you so much for continuing to do this work. We're going to come back every year.
And also, can we give?
Just lastly, really quickly, I just wanted to thank Devin Corbato, Jyoti Nanda, and Cheryl Harris, who were our faculty symposium committee. Thank you for all of your work on this.
And also, can you all join me in thanking Jasleen again for all of her work? first symposium. It's been awesome.
Well, I am looking forward to drinking and celebrating with you tonight at the dinner. So get over there so I can get a glass of wine.